Good afternoon, everyone, and welcome to our McLaughlin College Lunchtime Talk. To all the students that are here, could you please sign the attendance in the back of the room? That will enter you in a draw for a book that we give out at the end of each of our McLaughlin College talks. So I'm sure you might be interested in winning one of our books. And it also gives you an opportunity to be listed and considered for a certificate. If you attend at least six lunchtime talks, you get a certificate at the end of the year, which looks very nice on your resume. If you attend 10 or more, you get an honor certificate. So make sure you always sign the attendance sheet at our lunchtime talks. This is actually our last lunchtime talk for the academic year, and it couldn't happen on a better day. This is York Red and White Day.
Oh.
So at least some of us are dressed up in red and white to some extent, and this marks the 60th anniversary of our university, so it's a very auspicious occasion. We have one more function for the year that is being co-sponsored by the Center for Refugee Studies, the York Center for Public Policy and Law, and the Department of Sociology, and that is our Refugee Rights Day in Canada, and that will be on April the 4th. And since Alex is giving a talk on the Supreme Court of Canada, the Refugee Rights Day in Canada celebrates the 1985 Supreme Court of Canada judgment in the Singh decision. So please come out to that. We have a wonderful panel on that particular day as well. And that'll mark the official end for all of our either international days or our special events for the year. I'm very pleased to introduce someone that is very familiar to York University, Dr. Alex Wellington, who did a number of degrees here at York University. And now she is a professor at Ryerson University in the Department of Philosophy. Her research interests focus on public policy issues relating to theories of human rights, moral, and legal issues. And today she's going to be talking about legal rights under challenge, comparing the Supreme Court of Canada decisions, sex work, and MAID, medically assisted.
Medical assistance in dying.
In dying, thank you. So I'll turn things over to Dr. Wellington.
All right, thank you. So thank you for the warm welcome. I also wanted to give a special thanks to Andrew Molas and Vicky Carnivale for the organizing, inviting me to come to do this talk at the York Collegium for Practical Ethics, and also to the audience for coming. You're very welcome here. So I wanted to just say that a whole lot of what I personally have learned from practical ethics begins with what I learned at York. As was mentioned, I did a number of degrees here, undergraduate, in between graduate, philosophy, law, philosophy, and some other stuff along the way. I was one of those people who really enjoyed being a student, and I found that it's great to be back to York for a visit, especially with the subway coming here, which is so convenient. So I was hoping you'll all indulge me, and I was wondering if I could just ask everybody to say your first name so that I have a sense of people's names for when we can have some discussion. And I'll encourage people actually to have it as interactive as you like. You can ask questions or make comments throughout. So if anyone's not comfortable, you can just ask. But I really appreciate hearing everybody's first name. And I know the gentleman with the first, Russell?
Randall.
Randall, sorry.
Russell.
Randall.
Philip.
Yeah.
James.
Oh, we'll go with that. Miriam.
Oh, I'm Schwein.
Okay.
Amar.
Lena.
Evans.
Byra.
Sharon.
Ian.
Vicky? Yeah.
Marlon.
Ben.
Sorry.
And
Stan. Rob.
Heather? Great, thank you. I know I won't be able to remember all of your names, but I feel like it just helps to make an even more conducive atmosphere, to have a sense of people's names. So I wanted to talk about a project that's in progress. It's kind of underway, so I've got ideas I would like to propose and suggest, and I'd be really encouraged and be very grateful for any of your questions and comments and suggestions. So the project that I'm looking at is comparing these two Supreme Court cases. I'm looking at what led up to the cases, kind of how those cases evolved and unfolded, and then kind of what happened afterwards. So the overview of what I can talk about today is the reasons for the contrast, why I think it's worth doing. The commonalities, I'm especially interested in the commonalities between the people who pursued these cases and decided them, and the kinds of evidence, so the role of gender, lived experience, data, innovating judges, and also then what happened afterwards, right? So we had those Supreme Court decisions, and then there's all kinds of divergences that happened when it came to the contested narratives, the aftermath of the Supreme Court decision, the public policy options, and what government chose for legal reform. And so the framework that I want to bring to this is theorizing about the pursuit of social power through legal rights. And I think that these two particular cases are a really interesting way to look at this issue of how litigants are pursuing social power, but this can result in and generate resistance. And I wanted to kind of frame it in terms of resistance that can be seen as moral encroachment and political encroachment. And so I'll talk more about what I mean by those. So I just wanted to say that my preferred approach to practical ethics is becoming evident, involved in a combination of normative ethics, but also public policy analysis and legal, focusing on legal cases, because I have this interdisciplinary background, so I like to try to make the most of it. All right, so, whoops, I probably just pushed the wrong button. Thanks. Let's see if we can do that. Yay, okay. So there are these two cases. The Bedford case ended up in the Supreme Court in 2013, and the Carter case ended up in the Supreme Court. Their decision was released in 2015. So how many people have heard of these cases? Okay, good. So some people have. Anybody want to share kind of an impression about sort of like what those cases were about, or anything about those cases? Were they successful, or anything comes to mind? Anybody? Okay, well, as we go along, maybe people will have some more thoughts about these cases. So they do focus on some very controversial social practices. Bedford focuses on sex work or prostitution, and I'll use those terms interchangeably. Throughout the whole literature debating ethics and public policy about prostitution and sex work, people just go back and forth between those terms. Those who are advocates and their allies tend to prefer the term sex work, but lots of scholars and researchers will, as I said, go back and forth between the two. The other practice that's at the heart of the Carter case is the practice of medical aid in dying, which is also known as active voluntary euthanasia. And I can talk more about what those specific terms mean. And it is also a very controversial practice. Both of these issues, sex and death, right? So it's very difficult to be able to envisage human activities that are more intimate, more central to the self than the manner and circumstances of one's death, the when, the how, the with whom, and on what terms one experiences one's last moments of earthly existence, or the choices that one makes relating to when, how, with whom, and on what terms one engages in sexual intimacy. So, of course, sex and death, for anyone who's steeped in psychoanalysis, right, there will be that whole kind of resonance with Sigmund Freud talking about the life instinct, or eros, and the death instinct, or thanatos. So these are practices that are deeply significant to human life. And so perhaps it's not surprising that they would end up being practices that people have lots of very strong views on. And they ended up being practices that people who wanted to pursue a particular protection for their choices and recognition for their choices, chose to litigate about. So when I got interested about these two cases, now sometimes people kind of hear that I'm going to be talking about sex work and medical aid in dying, and it seems a little perplexing why the contrast between those two things. They're so different, right? They're so different. And some people might think there are other comparators. For sex work, you could compare commercial surrogacy. I've looked at some of that literature. For the medical aid in dying, sometimes we'll compare the marijuana. So there are different practices you can use for reasons of comparing. I found these ones to be particularly fruitful and fertile for my purposes. And part of that has to do with the way that these cases have been framed in the media and society. So we have this whole story that was played out in the media, that these were cases of people who challenged sections of the criminal code, right? So it's kind of the most restrictive type of law we have in society. It's law that applies across the country. So when we have a criminal code prohibition, it applies to everybody everywhere in the country. And these litigants challenge these particular criminal code prohibitions. And I'll say a little bit more about which ones they challenge. But they challenge them in the face of there being precedent decisions. So there were previous cases. So the Bedford case actually had a precedent case in 1990 called the Prostitution Reference Case, which is when the government put those sections of the criminal code relating to prostitution before the courts, and the courts upheld at least 2 of them that were being challenged. So that was a precedent. And then there was another precedent in the case of the Carter and medical aid in dying. There was a precedent of the Rodriguez case, right, over 2 decades earlier. It had gone before the Supreme Court, a similar claim saying that a person should have the right to medical aid in dying without having this criminally prohibited. And the majority of the Supreme Court in the Rodriguez case, or 5 judges to 4, had upheld those constitutional provisions. So if people are familiar with the way the legal system works in terms of the social norms, when there is a Supreme Court decision, the Supreme Court is the top of the legal pyramid. Those Supreme Court decisions are binding on all other courts at every other level in the whole system, right? So every other provincial courts and trial courts. So it was actually quite remarkable that the trial court judges departed from those precedent cases, and it's really interesting to think about what motivated them to depart. And then the Supreme Court itself came out with these decisions which actually departed from their own previous precedents. So it's so interesting in all those ways. But what I also found really, really fascinating is that after the Supreme Court decisions, which were basically framed as a win for the litigants, like they had challenged the criminal code prohibitions, and the judges all the way up to the Supreme Court ended up agreeing that those provisions were constitutionally invalid, really seriously problematic in many ways. And yet, after it was all over and the government came to decide amongst the policy options, what will we do next? They chose policy options that were quite different, right? So these cases were pursued by the litigants, their kind of self-representation of what they were looking for. They were wanting to move these issues out of the criminal law framework, right? To move them out of criminal law, put them into the context of health or labor. And when it came to the Carter case, there was some amount of success in having these social practices at least now found in the overlap between health law and criminal law, right? We can talk more about how exactly that all works. But the law that was passed, Bill C-14 in June 2016, actually did bring a health law framework and kind of mapped it on top of the criminal law infrastructure to deal with medical aid in dying, requests by patients for physician assistance in the end of life. But when it came to sex work, it was quite different. So the law that was passed in Bill C-36 in December of 2014 is a law that remains within the criminal law framework. And so it hasn't shifted over into the occupational and labor framework, which is what the litigants had wanted. And in many ways, there's actually kind of more criminal restrictions on certain activities. And so I think it's really interesting to find ways of understanding what did they have in common that helped them to be successful in terms of their challenges of the law in the Supreme Court, and then what are the differences that can help us understand how things worked out in the policy context. All right, so I wanted to just say a little bit, just for those of you who find it helpful to have some more background about who the people were and what exactly they were challenging. So in the Bedford case, there were 3 claimants. The case is called Bedford because it's in the name of one representative litigant, who is Terry Jean Bedford, but she was joined by Valerie Scott and Amy Lebovich, and so those are the 3 women that are portrayed here. And they were challenging the parts of the criminal code which made it a crime to have a body house, right? So people may be familiar with this term, right? It's a facility where the exchange of sex for money takes place, as well as other things. And so if anyone wanted to do what they call in-call, so be a sexual service provider to provide the service to the client inside their own home or other facilities, they would be potentially liable to be prosecuted under that section of the criminal code. And there was another section then that was called living on the avails. And the way it was framed was that anybody who got some kind of financial benefit that had been obtained through the exchange of sex for money could be liable to prosecution. And that had good purposes and motives. It was designed to deal with pimps, right? To people who are going to be exploiting sex workers, but it ended up that it could apply to anyone. So when sex workers wanted to be able to hire bodyguards, if they wanted to do an outcall, and they wanted to have a bodyguard to go with them, if they wanted to have security, if they wanted to be able to have any service provider work for them as they were trying to run a business for themselves, that person could be potentially prosecuted for living on the avails. And then the third section that they were challenging was the one that had to do with communicating in public for the purposes of exchanging sex for money. And the idea behind this one was that it had to do with what many people perceive as nuisance factors. This is the way the government framed it when they talked about the reason for having these kind of provision, is so that neighborhoods wouldn't have to have street prostitution going on. But it meant that what the researchers found, and there are many researchers who had studied how sex work is practiced by its practitioners and the implications of it, they found that in order to avoid being prosecuted for spending too long in public negotiating for the exchange of sex for money, service providers would tend to go into very remote, isolated areas. So for example, in Vancouver, there was an area called the Orange Light District, which was very far removed. It was an industrial area, so at night there was nobody around, but the police weren't going to be there, so sex workers felt it was safer to avoid prosecution. However, it ended up being really unsafe because that is the area where a huge number of sex workers were picked up by Robert Pickton, later found to have been the serial killer who killed a huge number of women, missing and murdered women, indigenous and non-indigenous women who had been sex workers, and also who had been drug users as well. So the argument that they were making was that these 3 provisions of the law, when they intersected and were interlocking, made it much less safe for women to be able to participate in the sex trade, which is what they've said is the goal for some women, to voluntarily, consensually partake in exchanging sex for money. And so this was a novel argument in the precedent case. They hadn't looked at these issues. They'd only looked at the liberty issues. So the challenge they made was that their Section 7 rights, for those who are familiar with the Charter, your right to life, liberty, and security of the person, they said were being infringed by the way those 3 laws work together. And they also said that this was going to be undermining particularly their autonomy, and they framed it in the security of the person. The former precedent case had just looked at liberty issues, right? So it's freedom of expression and other kinds of liberty issues. So that was the litigants, and as I mentioned, those are the 3 sections they challenged. That was the part of the Charter that they put most of their emphasis on. They later did also emphasize the freedom of expression section and said that the communicating in public, for example, had some negative repercussions for that. Although the final decision, as it ended up in the Supreme Court, they focused predominantly on the security of the person. And the way that Section 7 works from the Charter is that the government should not pass a law that infringes on a person's rights to life, liberty, and security of the person unless it's done in accordance with principles of fundamental justice. So it's kind of like you have this right that's protected, But if the infringement on the right is done in accordance with fundamental justice, then it can be justifiable. And that would make sense if we think about the fact that our criminal justice system has the potential for punishment, which would clearly be an infringement on liberty, but the argument is that provided it's done in accordance with these principles, perhaps a sense of substantive and procedural due process is invoked by that idea. Laws shouldn't be arbitrary or overbroad or grossly disproportionate. All right, so that was the whole context for the Bedford case. It went to the Ontario trial, Superior Court decision in September 2010, and then in the Ontario Court of Appeal was the next level up in March 2012, and then got to the Supreme Court in December 2013. And as I mentioned, it was actually the trial court judge who made the initial decision that those sections of the criminal code were an unconstitutional infringement on that part of the charter. Right? So it was originally the trial judge who came up with this very innovative decision. So now I can say a little bit about the Carter case and the litigants who pursued this case. So we have Sue Rodriguez, who pursued her case first in the early 1990s. She was a resident of British Columbia. She had a condition called ALS, which is a really long name and hard to pronounce. Amyotrophic lateral sclerosis. In popular culture, you'll often hear it referred to as Lou Gehrig's disease because he was the first person who was diagnosed with having this condition. And there's a really moving video clip that you can find online when Lou Gehrig announces to the huge baseball stadium that he has been given this diagnosis and that's going to be his career is ending. The other litigants, there were two of them. There was Gloria Taylor, who also had the same condition, ALS. And the features of this condition are especially terrible for the people who are experiencing it because it affects all of your motor functioning. So bit by bit, your body's not able to function, but your mind stays very clear and lucid. So there's no infringement and diminishment of your decision-making capacity, but you lose the ability to feed yourself, groom yourself, look after yourself, and are going to be dependent on people providing those health services for you in basic living. And so the argument that began with Sue Rodriguez was that if a person has the right to decide what happens with their body and their life, the autonomy and security of the person, then that should include the right to decide and have self-determination over how their life is going to end, the circumstances of their death. And this is one of the key arguments she wanted to make, is because of the condition she experienced, she would not be able to end her life herself, because she was physically not capable of doing so. And so she was making the argument that after 1972, suicide was no longer a crime in the criminal code. It was a crime before that. Although sort of practically, logistically, you could be charged for committing suicide only for the unsuccessful attempt, right? Because you're beyond the law if you were succeeding. But she argued that, suicide had been decriminalized, and she said that reflected sort of changing values in society. And also that our healthcare system recognizes the right to informed consent. And for anybody who is a mentally competent adult, a decision maker, a mature minor, you can choose whether or not to undergo a healthcare treatment or have a healthcare service if you know the risks, the benefits, the alternatives to treatment, and the consequences of non-treatment. And she said, why shouldn't assistance at the end of life be treated the same way? The other person who joined this litigation was Kathleen Carter. She had a different condition. It was called spinal stenosis. It wasn't a disease that was going to have the prognosis of a really short lifespan, such as ALS. Like ALS, once you're diagnosed, you don't have very long to live after that, and your body just will continue to decline until you're going to suffocate to death or starve to death. But with spinal stenosis, somebody could go for quite a long time, but with considerable pain and discomfort. And she thought she should also be able to have access to medical aid in dying. In her case, it was interesting. She had her daughter, Lee Carter, who was willing to accompany her to get the service she wanted, which is end-of-life help, at a clinic in Switzerland called Dignitas. So Switzerland is one of the countries in the world that has set up a clinic that will actually provide the service of end of life to non-residents. So many other jurisdictions that have decriminalized, Netherlands, Luxembourg, etc., will often require you to be a resident. But in Switzerland, you don't have to be. And so her daughter and son-in-law, Hollis Johnson, a criminology professor in British Columbia, wanted to go with her. And they were worried that they could be subject to prosecution. Because the way that the law worked was that there was a criminal code prohibition against assisting suicide. So the person who takes part in the assisted suicide isn't going to necessarily be subject to prosecution, but the person who provides the assistance is captured by this criminal code provision. And it was a blanket prohibition when it was challenged, which meant that there were no exceptions, no conditions, no qualifications, just anyone, anywhere, for any reason who wanted to assist a suicide, even if that person voluntarily consented or requested, would be captured by this criminal code prohibition. It had a really long sentence, could be up to 14 years of punishment. So it's a pretty strong criminal offense. And there was another section of the criminal code which went along with that one, kind of working in tandem, which is that you cannot consent to death. Right? So they kind of two went together to make it impossible for anyone to legally have medical aid in dying. And this one went to the British Columbia Supreme Court, which is the trial court, and the judge overturned, reversed the precedent, and found that it was unconstitutional. It was going to infringe on somebody's right to security of the person, as well as their liberty, especially their autonomy, not to be able to have medical aid in dying, should they so choose. And then that went to the British Columbia Court of Appeal in 2013, and then finally the Supreme Court in 2015. So are there any questions about just the kind of the basics about the cases and what was going on, what they were challenging? Anything so far? Okay, great. So I will keep going. So the first kind of conceptual analysis that I wanted to look at for these two cases in their contrast has to do with the commonalities between them, because I just found it really intriguing how many commonalities there were in terms of who was taking these cases and the kind of the process of the litigation. So here's some of the key similarities that I have highlighted. One has to do with the persons who are litigating, and I just think it's really so interesting how many of them were women. So in the sex work case, the three litigants were all women: Tara Jane Bedford, Amy Libovich, and Valerie Scott. They were also focusing on their lived experiences. So Tara Jane Bedford had been a former professional dominatrix. Valerie Scott, at the time of the litigation, said that she was a retired sex worker, although once the Supreme Court case came out, she did go back to working in the field. I've spoken to her about being a guest speaker, and she talked about how she has to arrange any of her guest speaking around her night work. And Amy Libovich did not appear in the media while the case was going on because she was continuing to work as a sex worker while they were challenging those criminal code provisions. So she was clearly still engaged in what our law was determining to be criminal behavior. So she never appeared in public. She was also pursuing a master's in social work at my university, Ryerson University, while she was doing that. Once the Supreme Court came out with their decision, then she came public. But they were basing it on their lived experiences, which I think is a significant role to play in this whole case. And in the MAID, the context of MAID, or medical aid in dying or euthanasia, we had predominantly female litigants. We had Sue Rodriguez and Gloria Taylor, as I talked about, and Kathleen K. Carter, as well as her daughter. And then we had a son-in-law and a Dr. William Sorchett. But in addition to that, I wanted to emphasize that if anyone's familiar with the developments in the law relating to euthanasia, and I guess just to give us the most basic understanding of euthanasia, the idea is that it's supposed to be a good death, right? So the idea of the mercy, having a more compassionate way of ending one's life. And so many of the cases in Canada have actually been pursued by women. So we have Nancy B. in the case of Nancy B. versus Hotel Dieu de Quebec, who was arguing for being able to have herself taken off life support when she chose and was ready to no longer continue. And then we have another famous case known as Millette versus Schulman, which involved Georgette Millette, who was a woman who is a member of the Jehovah's Witness faith community and was brought into an emergency hospital after a car accident. The doctor wanted to give her life-saving blood transfusion. It was a very complex situation, but she did have a card in her purse saying, "I'm a member of Jehovah's Witness faith community. I would not accept a blood transfusion." Then her daughter showed up at the hospital emergency room a little while later and said, "My mother would definitely refuse a blood transfusion, even, if she was conscious at this moment, which she was unconscious, she would refuse it." The doctor went ahead and transfused her to save her life because he felt he had a moral obligation to save life. The courts ended up saying, if you're a mentally competent adult with decision-making capacity, you have the right to refuse treatment. So you have the right to ask for it to not be initiated, so non-initiation, to have it withdrawn if it's going on, right? Withholding, withdrawn, and that right was being affirmed in that case, so those are also women. And in the United States, if anyone has followed the debates about euthanasia, there are so many end-of-life cases that have ignited firestorms of public debate and attracted such substantial amounts of media coverage, who have involved women, including Elizabeth Bouvier, Nancy Cruzan, Brittany Maynard, Karen Ann Quinlan, and Terry Schreiber. So I just thought gender is a really interesting factor here. The other really interesting factor in looking at the differences between the precedent cases and the contemporary cases has to do with the role of social science evidence. So this was something that when the judges had to figure out, can we depart from the precedent, right? Because the judges are tasked with the responsibility of upholding a continuity in law. That's what the whole idea of precedent is, right? It's this Latin phrase, let the dogs lie, which is the idea that once the case has been decided, you should adhere to the ruling in the future, particularly in the hierarchical court system. So lower courts are bound by higher court decisions. So the judges had to figure out what could motivate us to depart from precedent. And one of the things that they said was social science evidence about the practice that's being challenged and what the implications are of this social science evidence. So just to give you some numbers, so those are interested in numbers. In the Bedford case, Justice Susan Himmel recounted that over 25,000 pages in 88 volumes of evidence from social science and 18 witnesses, right? And that ends up in a decision. It's a really long decision to wade through. It's like 541 paragraphs. And a lot of that is talking about what that social science evidence was and what its significance is. And this is something that all of that evidence shows how different our understanding is of that practice from the previous prostitution reference case, right? So the judges are trying to say that we now have so much more information about how these criminal code prohibitions are affecting the lived experiences of sex workers. So in the context, that's the Bedford case, in the context of the Carter case, there's even more evidence that they look at. There are 36 binders with 116 affidavits, 57 expert witnesses, right? And so you can start to see like how much bigger the social science data is that comes into that case. The trial decision consisted of 1,421 paragraphs, so it's about 2.5 times longer than the Bedford case. So each time what the judges are doing is collecting an accumulation of research from people who are being impacted. So in the Carter case, there were so many affidavits from people who had to live with really challenging, incredibly difficult health conditions. There was a lot of evidence from people who were saying, I'm mentally competent and I'm physically able to end my life, but I don't want to end my life now, but if I wait, then I will lose the physical capacity to be able to end my life. And so I am being pressured and forced, I feel, by this legal restriction to end my life sooner when I can do it by myself without help. Right? So this was called the premature suicide risk factor. This was something that had never been considered in the Rodriguez case at all. The judges had not even looked at that because there wasn't this empirical base from lived experience that people were going through. So it's really, I think, very, very interesting for anyone who's interested in the role of social science in the context of law and policy to look at these cases. And there's been some interesting legal commentary by a lawyer, Joseph Cheng, and a legal scholar, Jody Lazar, on just how social science evidence played a role for the judges. Another commonality that I think is really, really interesting is that the innovating judges, which are the trial judges, were both women. So I think gender is also interesting for that reason. Disciplinary background, I think, is also interesting because Justice Lynn Smith's background was in philosophy. So as somebody who has studied philosophy, I always find that relevant. Of course, it's also relevant that Chief Justice Beverly McLaughlin, who was the Chief Justice for both of these cases, also studied philosophy in her undergrad. I don't know how much to make of gender in terms of judges. There's been a fair bit of discussion among scholars about this. So there's one project that's called the Feminist Judgments Project, and the scholar Rosemary Hunter has kind of reviewed those findings and said, you know, the evidence is ultimately inconclusive as to whether it makes such a significant difference, the gender of a judge. But she still insists, and I think this is important to be emphasizing, that there are many other good reasons to have a diverse judiciary. Right, so the presence of non-traditional judges has great symbolic significance and importance and how they manage their courtrooms, and the contributions they'll make behind the scenes and extrajudicially. And so many people will talk about the contributions that Beverly McLaughlin made as Chief Justice in terms of trying to get consensus decisions, trying to have a lot more awareness in the public of what judges do and their role and how seriously they take their responsibilities. So, you know, gender may have a kind of indirect effect, but I do think it was interesting that both of those judges who what people would say took this pretty radical, innovative approach to their decisions were females. And then another really significant factor was that these are decisions that by the time the Supreme Court came to release their decision in Bedford and in Carter were unanimous decisions. So for those who read your way through law decisions, and particularly decisions coming from the Supreme Court, they do not always agree with each other. When you're teaching cases from a philosophical perspective, it's fascinating when they don't agree, because there's so much to learn from how differently they view the issues before them and how to apply the law, how to interpret it. And so the fact that it's unanimous is also very significant, particularly because the previous two cases that were precedent had dissenting decisions. And there's a lot of discussion about them making these decisions anonymously in the context of the Carter case. So in the Bedford case, it's unanimous but authored by Chief Justice Beverly McLaughlin. When it came to the Carter case, they didn't even put an author on. So that's kind of an interesting thing, and there's been legal academic or political scientist, actually, Peter McCormack, who's written about this. He calls this the untold story of a Canadian judicial innovation. Right? So he said that that's a Canadian judicial innovation to give this unanimous, anonymous ruling. It doesn't happen often. U.S. Burns was one where they departed quite significantly from a precedent, a divided precedent with a significant dissent in the Kindler and Ng cases, which this is about capital punishment, extradition. So anyways, that was, I thought, was another really interesting commonality, is that the judges all agreed about the unconstitutionality of those provisions in both cases. So the framework for analysis that I'm developing, and this is sort of where I'm kind of going with looking at these cases, is to, from the foundations and the building blocks of the commonalities, is then to look at where the divergences come in, right? Because that's what I'm especially interested in, is there's all these commonalities, so how did they end up with such different outcomes at the end of the day? And trying to understand more about those outcomes. So the framework for analysis that I'm developing, I actually reversed the sequence. Chronologically, Bedford came to the Supreme Court before Carter, but I think it's easier to look at Carter first in terms of trying to understand how the litigants in that case had some modest success, right? They didn't get everything they thought they should get, but they did have fairly modest success of moving the practice into the the intersection between criminal law and health law. So I like to look at the Carter first and try to focus on core themes, the opposition, the resistance to their legal rights, looking at the policy options, the choices government had, and then why they made the choices that they did. And the divergences, I think, can be really seen most clearly in the context of the social identities of the groups who were litigating, right? So the difference between it being the care providers, service providers, who were being potentially criminalized in the Bedford case, right? And the care who shifted over to no longer being criminalized later. But when we get into the medical aid in dying, it was the providers who were going to be criminalized. It was the recipients who were asking for it to be decriminalized. So you get a different interplay, right, between what's being asked for and who would be the ones to provide what's being asked for. So I think that's very significant. And the effects on third parties also, I think, are really hugely important. So just to highlight some of these core themes that I have noticed in this analysis of these cases. So these core themes have to do with that they had a shared vision, I think, the litigants, of individual rights and the role that legal rights can play in getting social power. And I think that they were all pretty mindful of the way that they needed to do litigation to get the social power to do what they wanted to do. I don't know if people know about what ended up happening with Sue Rodriguez, but after she lost at the Supreme Court, they were unsuccessful. She actually did get the medical aid in dying that she had wanted. She was at home. A medical professional came and provided her with end-of-life care. There was a politician there, Sven Robinson, NDP, who had been supporting her all throughout. And after this was announced that she had gotten the end that she wanted, the police said that there was insufficient information for them to be able to prosecute anyway. So they weren't going to be able to pursue and follow up the prosecution. So she did get what she wanted, but it wasn't legal. And so what the litigants in the more contemporary context, Kay Carter, Gloria Taylor, and all of the people who supported them were arguing for is that this is something that they wanted to have the social power to be able to negotiate this with their healthcare providers on their own terms in their own way. And when it came to the sex workers, they were also arguing that they should have the rights as individuals to be able to voluntarily choose to negotiate the terms under which they would exchange sexual services for financial remuneration, and they wanted to be able to exercise that control by able to do that with more legal power, social power through legal rights. So that was what they were pursuing. What happened when these cases go through the courts is that the government has to defend the criminal law. So the way that a charter case works is a person says, my charter rights have been infringed. You go before the judges and you say how you believe your rights were infringed. And then the government has to explain why do they think that there should be a law that could infringe the rights of the citizens, right? So the government will then go and say, here are the reasons why we think this law should be there. We have these pressing and compelling objectives and purposes and goals for this law. And so the kinds of things that the government pointed to were all of these really fascinating philosophical issues about consent and all kinds of challenges to the notion of voluntariness and how circumstances impact on voluntariness. So there was lots and lots of evidence in the Carter case. Start with the MAID one first. Doctors who came in and said that people who have these debilitating conditions can suffer from depression. It can have all kinds of impact on their decision making. And so the government was calling into question the capacity for someone to be able to voluntarily choose to have their life ended. Because they were saying there's all kinds of questions about that capacity. To respond to that, the litigants then would bring in all kinds of people who insisted that they were not depressed, that they had full understanding of their emotional states, and they had really good appreciation about life and its value, and for them particularly kind of the ambiguity about the value of life in terms of just mere existence. And they insisted that they would be able to give valid and properly informed consent. And they brought in healthcare providers who argue that if you are someone who's going to specialize in providing end-of-life care, you're going to be able to make those determinations about who is sufficiently acting voluntarily, right, not being overly persuaded by emotional or social pressure. And so they insisted that this is a decision that person can make and that a healthcare provider can assess. When it came to sex work, wow, that got so messy about issues of consent. It got incredibly messy, and it still continues to this day to be messy. The litigants themselves said, we're very able to determine on what terms we're going to exchange sex for financial remuneration, and we are doing this voluntarily. Some of the social scientist evidence that came in about the sex work case suggested that things are really kind of murky, depending on the type of social position of a sex worker, right? So this is where the social science became so important, because there's these differences between people's social locatedness. You can have people who are what's known as high-end hall girls who have education, opportunities, make fairly reasonably good amounts of money, and could choose to do other things, choose to do sex work, and have a fair bit of control over who their clients are, when they see them, and what they do with them. And then you're going to get another whole part of sex work, which is the one that everybody is genuinely worried about for very, very good reason, what's known as sexual survival sex work, right? It's called survival sex work. It's something that people take part in if they have either a history of sexual or domestic abuse, they might have drug addiction issues, they may have not very many educational opportunities or accomplishments or achievements, and so they have a sense that they are not really choosing this, right? And this is what, again, the lived experience evidence comes in, is that you get people who are saying, this isn't really something I was choosing, I felt obligated or compelled in order to try to make a living somehow, to take part in sex work. And then we have the whole issue of human trafficking, right, which is like hugely complicated, and I can just set it aside. If anyone wants to have more talks about it, we can. But even just setting aside trafficking, even amongst those people who say, I haven't necessarily been trafficked, there's a huge difference between people who feel that they were quite consensually, voluntarily taking part in sex work, and many people who have huge regrets and say that looking back when they have been able to exit, that they were not really that voluntarily participating. So that's a huge issue, and it's very complicated. And the government, in a way, took a number of kind of stances and approaches to justifying the law. One of them was to call into question the voluntariness, but another one was to simply say that even when people choose it, the violence that could ensue in terms of the violence from clients, the risk of diseases, so health risks and physical threats to your physical welfare and well-being, those are something that are chosen by people who take part in sex work, right? So they choose. So the government had these kind of different arguments going on about choice. And they said it's not the law that makes it risky, right? Because the litigants were arguing that it was the intersection of those provisions, the way the law was restricting their options, that made it more risky. The government was trying to say, no, it's the choice to take part in sex work, that's where the risk comes in. And then they also tried to talk about the nuisance factors and wanting to have, particularly street prostitution, not being on the streets. So there are a whole number of issues that came up about consent and voluntariness. And so I think it's far more complicated when it gets to sex work than MAID. And again, I think that shows an important difference when it comes to what happens afterwards. And of course, concern for protection of vulnerable persons, right? Which is huge. And it's part of what many people say we have criminal law for, right? As well as human rights. We have it in order to protect people who are especially vulnerable, and to make sure that they get protection. And so the types of protection, of course, in the context of MAID, that was brought up in the Carter case, was the emotional pressure, the psychological pressure that people feel when they're at the end of life, and they feel they're a burden on their families, their loved ones, and society in general. And there were people who said that they're worried that the decriminalization of medical aid in dying would lead people to think that it's not just accepted, but expected for people to request end of life. And so that's a huge issue of how to try to protect people. And then, of course, in the context of sex work, protecting vulnerable persons from exploitation, commodification, objectification. So these are core themes. Another aspect of it that I'd like to focus on is this sense that when you look at the narratives of the litigants who are pursuing the narrative of why they want to get these legal rights, why they feel that they deserve them, why they feel that the law that prevents them from having these legal rights is unjustified, you also have all of the critics. So there wasn't just the government trying to defend the law, but there were many interveners. So I'm not sure how many people of you looked at a Supreme Court decision on a hot public policy issue. You'll see this, the parties, right? So the challengers and the government. Then you'll see this long list of interveners. And what that is groups of people who are really concerned about the issues at stake. And they go to the court and request, could we put in an intervener submission? Either it can be in writing, or sometimes they can appear orally, and if you're a lawyer, like it's a big deal, it's a great privilege and honor to be able to appear before the Supreme Court and when they're making these legal arguments and be an intervener, and in the trial court as well. So as the cases went through the system, they collected more and more interveners. So by looking at the interveners, I find you can get some really interesting insight into the kinds of moral and political positions that people presented for why those legal rights shouldn't be recognized, right? So reasons that they thought should lead to denial of the social power that the litigants were seeking. And I wanted to divide them into at least two different categories. I think there are many more, but at least as an initial kind of framing, I wanted to look at what I consider to be a potential moral encroachment on legal rights. So I wanted to see legal rights as something kind of distinct and unique and very particular and specific, and then to look at what people's arguments are that are morally oriented and founded and grounded in morality. And in the context of both medical aid in dying and in sex work, you see these arguments that are rooted in norms relating to the sanctity of life, the wrongness of killing. People may be familiar with this if you've done any courses in ethics. You'll hear about the sanctity of life, the view that all life, particularly human life, has unique and special value. Each and every human life is of equal worth, and life has value because of existence. Okay? So this is in contrast to the quality of life perspective, which many people who are advocating for end of life put forward and saying, I should be able to decide whether my life has enough good quality or whether there's so many negative experiences, the pain and suffering, the displeasure, unhappiness, lack of satisfaction, lack of enjoyment. And so the argument in quality of life is that you can assess that some lives, some quality or periods, some states of existence are of more value than others, which the implication of that is that some lives may be not worth living. And the advocates were making that claim for themselves, right? Stu Rodriguez, Gloria Taylor, and King Carter were saying, I'm deciding that about my life. There's going to be a point where it won't be worth living for me. That was directly contradicted by people who said that, we should never make any judgments about relative values of lives, even for oneself, and certainly not for other people. In the context of the sex work case, we had all kinds of moral norms grounded in religiously based morality and traditional notions of virtue, about conventions about gender, family values, about the importance of sexuality combined with intimacy in terms of close relationships with commitments and bonding, which sex work goes completely against the grain, right? Because it's all about an instrumental exchange of sex for money. And there's all kinds of issues as well about bringing money into it. For many people that problematizes things excessively. If it's just an altruistic exchange, people seem typically are a lot less concerned. But bringing money in raises all these moral issues. What I found interesting, though, when I was starting to look into the people who were objecting and criticizing, was that there was kind of another thread that I found in both of the cases, which has to do with more of a political articulation of interests. And this also could, I frame this as being a potential encroachment because it's using these political arguments to say, here's why we think those people shouldn't get their legal rights. They shouldn't have that social power. And this had to do with a vision of emancipatory and liberatory and revolutionary politics, right? The sense that we should be aiming at anti-oppression, anti-subordination, and anti-domination, and that individual rights for some people could potentially jeopardize that vision for greater social justice. This is actually a much more complicated story, but it is one that I've seen. It's in the MAID context, you'll have people who are advocates for persons with disabilities, who will say that our lives have value, we deserve to have dignity, and they are really offended by the notion that end-of-life care is in a way an implication that the life of a person with these significant health challenges doesn't have sufficient value, right? So they're really reacting against that. And their view is that if we want to have a society which would truly value the contributions and the dignity of persons with disabilities, we would not give legal acceptance to medical aid in dying. And there's actually a professor, Catherine Frazee, who for quite a while was teaching disability studies at Ryerson. And she actually taught the ethics and disability course for the philosophy department. And she was very publicly, very, very opposed to medical aid in dying, any kind of decriminalization at all. She was on a special task force to put that perspective forward. And so I just found it very interesting that there's this real tension between individuals pursuing rights and the idea of the goals for the larger society. Yes, it's Randall, right?
Yes,
Yes.
it's, if I may please voice an opinion,
Please.
I would be in total agreement with Miss Frazee to a large degree, and also, take it or leave it if you want, but the way I look at it is that life is a gift from God, and for you to just end your own life like that, that's almost like slapping God in the mouth. That's the way I think now when I'm well and I'm thinking the way I would normally think. But I've had discouraging situations where, as I have at times felt my life may just as well be terminated, that I've lived long enough. What's really left except painful existence? Now I would be very happy to see this Miss Frazee, so when you're done with your talk and everyone else has had their stand and their say and everything, come and see me and I'll give you my number, and I would love to have a talk with Miss Frazee, because the first thesis statement that I gave to you, that is the stand that I wish to take. Although I do get very discouraged, and I'd love to hear from Miss Frazee and other people like that, how you could combat the other way of thinking, and the way that it is. That the way I'm looking at it right now, that's up to God when I go, and not up to myself or anyone else to say, well, you're done, get out of here. That's not our call. So the best thing I'm trying to do is keep myself as busy as I can and active in whatever communities I can feel at home at. Like this one, for a perfect example, is one of the best I see. And I would try to keep myself busy, and if I should be lucky to keep on going, even while I'm a grandfather in my 70s, well, that's a plus on my side, because Johnny Cowan, the trumpeter, had that same kind of an experience. He was well in his 70s, and he's still playing. He was still playing for the TSO the last that I heard, and he's on a marvelous life. So to a degree, life is basically what you put into it or what you don't put into it, and it's a conscious choice, although there could be some other things I don't understand about.
very much for sharing those insights. And you so eloquently articulated those ideas that have motivated many of the critics. Yeah, I really appreciate that.
Well, I hope so. I hope I didn't upset you.
No,
I don't want to be the one who spits in your cereal.
The great thing about, I think, both philosophy and law is that everything is welcome as, an idea to be considering, and I really, really appreciate the way that you have expressed those views very much. So maybe this is a good time to open it up then. Randall's been the brave person to speak up first. Does anybody want to contribute questions, comments? Yes, Ian.
Well, Alex, thank you very much for a wonderful, wonderful presentation. It's so insightful. You did so much research already, and I'm looking forward to the results of the continued research that you do. The question that I found very interesting was the fact that McLaughlin and Smith and other women were part of the decision-making process in Carter and Medford. And of course, it's, I guess another question would be, because the judges had to work with the materials that they got from the litigants.
Yes.
To what extent were the lawyers women? I think it was probably a mixture of women and men with regard to the preparation of all these documents.
Yes.
And for McLaughlin, I think the three things that motivated her: first of all, the rule of law, and then second, the what she called conscious objectivity. Another word for that is compassion. And then evidence. She was just so good at wading through volumes and volumes of evidence. I think much better than most of her colleagues, male or female. And coming up with a really solid assessment of the strength of the evidence on both sides. Yes. Now, is that because she was a woman, or because of who she is as a person? And I tend to think it's the latter, who she is as a person. Part of that was her philosophy degree, undergraduate and graduate at the University of Alberta. But she had an ability to try to objectively look at all the evidence without making up her mind, and then saying, well, where is the preponderance of evidence? Where does this go? And other people would have said, well, maybe unconsciously, this upsets the status quo. But maybe the womanhood is, why should things always be the same? Why can't they be different? And they always have to be the same as they were 100 years ago? No. So, personhood, womanhood. Do you have any comments about that?
So it's a great question, and I might kind of come back to that after I go through a few more of the fascinating points that you've raised, and kind of come back to that one. So you did ask about the lawyers, which is always so interesting. I'm always interested when lawyers write their own pieces, talking about sort of their role in the very significant litigation. So the lawyers that played the biggest role in the Carter case were from the British Columbia Civil Liberties Association. They basically kind of shepherded this through. And I didn't mention this, but it is significant that both of the key litigants died before this ever got to the Supreme Court. So Kate Carter did get her death in dignitas before the Supreme Court decided. And Gloria Taylor, after the trial court declared the criminal code those provisions unconstitutional and said the remedy is a declaration of invalidity suspended, except for the one individual who is Gloria Taylor, still alive. She ended up dying of natural causes, so she actually didn't need it. So the British Columbia Civil Liberties, what's interesting is their role, they actually became the litigants, in the absence of the women who had departed. When it gets to the Bradford case, the lawyer who had the biggest role in helping them frame their work was a male. It was Alan Young, who's a criminal law professor at Osgoode Hall Law School.
And he's given talks here.
And yes, I was going to say, and he's had a lot to say about, he really helped to craft it very innovatively. And I had a brief conversation with Valerie Scott when I was trying to arrange a guest visit to my class. And she was saying that, for her, all the legal complexities of it is sort of a little bit, outside of her pay grade in a sense, right? So she really attributes him as making so many of those legal arguments that framed the litigation. So that's, I think, interesting to note. You had also talked about the attitudes of the personalities of the judges. I do think it is really interesting to note, to see the dissent. I mean, so many people said that when you read the dissent in Rodriguez, you had Lemur and McLaughlin, and I forget who the third person was who dissented in, it was Lujube, and then there was another one, I believe, Corey. It was Corey, I think.
So,
Yes, it was Corey. And so when you had all of those judges dissenting, you'll see how much kind of philosophical reasoning came, particularly from the combined dissent that's co-authored with McLaughlin and Lujube. And then you see a lot of that philosophy coming back again in the consensus decision in Carter. But it's also interesting to note that there were other judges, the judge who authored the majority decision, John Sabinka, who actually went on the news and said that the hardest case of his entire legal career was the Rodriguez case. He said it was absolutely devastating for them to see the video of her saying, "Who owns my body? Whose body is this?" And he was really, really moved by that. But I guess he did feel perhaps more swayed, and certainly that comes out in the reasoning by the sanctity of life perspective. He tried to interpret that as part of the principles of fundamental justice. He saw that so strongly, and he said he didn't want the state to ever be seen to be condoning suicide. So you get a sense then of the kind of value perspectives that they bring in. But one more point I want to mention about what's so significant about that divided decision was that if one judge switched, it would have been a majority in favor. And John Major has in later interviews said, "I had just joined the Supreme Court. I was brand new." And he said, "I really thought the arguments were very strong in favor of decriminalization. But," he said, "I really believed the government was going to move and change the law, because all the public opinion polls were showing that the Canadian public was overwhelmingly, progressively more and more in favor of medical aid in dying." And he has said, he hasn't quite come out and said that he would have decided differently had he known that 2 decades later they wouldn't have changed the law yet. But he certainly said that that was an assumption that went into him joining the majority. So I just think that's also another interesting thing about the personality of the judges. So then that brings me back to the gender factor, which I personally am so intrigued by. But as I said, when I looked into the literature, there are other scholars, Mary J. Mossman at Oxford Law School, have done a whole lot of work on gender and judging and the biographies of judges. And I find it really intriguing, but it is sometimes difficult to attribute that, because then I went and looked at the gender of the judges at the appeal courts, which didn't uphold the trial court judges. And there are quite a few women in that. So I guess and then when you look at the consensus decisions and unanimous decisions, there are quite a few men. So I kind of think gender is really important to be paying attention to, but I don't know how much we can attribute to it causally. So, but and it's a great question. Yes, and just remind me your name again?
Sorry.
Sorry. Okay.
It's just funny, I've always thought Bedford as a case, was one of these cases which has always been contingent on social science evidence, right? And there are lots of cases that are contingent on scientific evidence, like maybe or is the HIV disclosure case,
Yeah.
which are some rules, which is very directly contingent. So then today I had to put Carter in that group of cases, so that I appreciate.
And I'll just recommend that there's actually been a whole article by Jody Lazaire, which looks just at the role of the social science evidence in the Carter case. So it's really worth looking at. So people are starting to really notice that case in this context.
The other thing, just think about the legal history going from Rodriguez to Carter, there's also Latimer in there.
Yeah.
And I think in terms of the opposition that to Carter and from the disabilities, disability studies community primarily, really seems to be heavily informed by the arguments that were made by the defense in Latimer.
Yeah.
And just a comment, I suppose.
It's a great insight, because also when I'm teaching philosophy of law, I look at the Latimer case as well, because students find that so gripping, that case. And when you look at the media coverage, there were a lot of people who are from the groups who represent persons with disability who had headlines like "Afraid for Our Lives." And for sure, when it came to the whole debates, like another interesting difference between sex work and medical aid and dying is that we have had Senate committees, we've had government proposals for going back over the decades in terms of decriminalizing active voluntary euthanasia. But what you do find is all throughout that, a lot of resistance, because what is this going to mean for persons with disabilities? And that's been the tension has been sort of all throughout that process. Yeah. So, other comments, questions, insights, puzzlements? Yes, James.
Perhaps you're familiar with Sean Head's work on refugee determination, and he's looked at gender. And the studies that have been done in the United States in terms of adjudication between men and women, there is a sharp difference between men decision makers and judges and women judges. However,
Okay.
Sean has found that that's not the case in Canada.
Oh, how interesting.
It's
Nationality
not-
and gender.
Yeah, that could be an aspect that you might want to consider as well.
That would be really interesting. It'd be
And
interesting to know more about how people are appointed to be adjudicators. How politicized it is or not.
But it's very politicized in the United States, I
Is it?
think, yeah.
Yeah. But that is really intriguing. Okay, yes.
You mentioned my friend Peter McCormick and the research that he's done. One of the other new findings that he's come up with is that in Lemaire Court, in every single court under a Chief Justice before Lemaire, there were always voting blocks. Groups of judges that tended to vote together, and groups of judges that tended to dissent, sometimes on different kinds of issues.
Right.
And he did the same analysis for the McLaughlin court.
Ah.
There were no groups like this.
Oh, wow.
Why is that the case?
Yeah.
Well, Peter and I were lucky enough to interview Beverly McLaughlin a year ago.
Oh, great.
And Peter explained this finding, and he said, why do you think this is the case? And she was shocked. She said, I had no idea.
Oh.
But she said, I try to get, I don't try to encourage the judges not to dissent when they want to dissent.
Yeah.
But I try to encourage them to look at points of view that they might not initially agree with.
Yeah.
And look at those points of view very carefully. She said maybe that's had an impact.
Well, that's fascinating.
Yeah.
So it sort of gave her some more insight into something that she might have been doing implicitly.
That's right.
Yeah.
Mhm. But I think that reflects her own personality, where she does try to look at all sides
Yeah.
as impartially as she can, and then make up her mind.
Yeah.
And she learned that from being a philosopher.
I would suggest that, yes, yeah, and I would think that she, would recognize that that's part of what she would have obtained from having done. She said she seriously considered graduate school in philosophy and law. I'm sure the whole legal community is very happy she chose the path she did. She had such an impact on the Supreme Court for so many years, but I think she would credit it have given her something, good background. Yes, Dan, sorry.
I've got her her master's thesis if you want to read it.
Oh, I'd love to read it actually,
I'll send
yeah.
it to you.
Yeah, that would be great. I'd be really interested. Yeah, it'd be really good. So, Stan, philosopher,
So
you know something
I
to say
don't know
about?
much. I don't know anything about what you were talking about. But has there ever been an appeal of a judgment on the basis of gender bias? I mean, we're talking here about women, men.
Yeah.
Has any enterprising lawyer ever come up and said, "I think there's evidence that there is some gender bias in the judgment"?
Such an interesting question. I think the social scientists, political scientists, would be better situated perhaps to answer that.
I just meant empirically.
Yeah, no, I don't know. Does anyone know? Yeah.
I was once an expert witness in a case that was all about bias, and it was about a particular judge in the federal court
Yeah.
who decided consistently in one way. I collected the evidence to show that he was very consistently biased.
Yeah.
But it didn't have anything to do with gender. It was his particular approach.
I mean, there have been allegations of judicial misconduct around gender, most recently in Manitoba we have. So, I mean, there have been allegations and successful cases we have we've had allegations of racial bias.
Mhm.
So, I mean, there are bias cases.
Oh, I
there
know.
are factors.
Yeah.
But in terms of identifying, I think Ian's response is closest to the kind of thing.
But it is intriguing, right? Because lawyers are always looking for a new angle
That's right.
to be able to challenge decisions. So it could be an interesting one for them to consider.
Then you get the cases of both, several women judges. People sent complaints to the Canadian Judicial Council that they were biased because of their remarks about gender. Of course, it was ignored.
That's
Yeah.
probably
It's really interesting now how there is so much more focus on judges and things that they say. Like there is a lot more public scrutiny in the media than there had been before. And there's a lot more, when I go to the Canadian Political Science Association meetings, I'll hear a lot more research that's being done interviewing judges, which is also a source of fascinating insights. And I think that's all kind of developed over the years as people have, and judges are maybe more willing to be interviewed, right? And to take part in that as part of their accountability. One of the most interesting insights, and I always try to tell students this, that I saw a judge making, I think it might have been Beverly McLaughlin, but I have to go back and check, it was quite a while. But the judge was saying, people criticize our decisions, right? Because the Supreme Court decision comes up and you get all these decisions. And this judge said, but what they have to realize is that our responsibility as judges is to make a decision, right? We cannot do what people can do in the ethical or philosophical realm and say, well, let's just keep debating it. We'll just keep debating it. They have to come up with a decision. And this judge was saying that, we take that responsibility really seriously. So I just thought, and it's part of the role of what we look to the courts for in society. Yeah, so thank you. Your
Yes, on behalf of the members of McLaughlin College, we'd like to give you this token of our appreciation for your presentation today.
Great.
And hopefully you'll put this in a place of honor, remember us.
I will, thank you. And I'm so touched to know that you said this is like the anniversary, the red and white day, that makes it
Exactly.
extra special. Yeah.
Thank you so much for joining.
Yeah, thank you.